You may have heard of the Public Safety Act, but what does it mean for you, and how does it make Tennessee safer? Let's start at the beginning. In 2011, Governor Bill Haslam created the Public Safety Sub-Cabinet with all agencies involved in public safety and law enforcement. To find out the challenges facing Tennesseans, that group held meetings with more than 250 stakeholders across the criminal justice community. Some of the initiatives that came out of those meetings that really impacted the Department of Correction were the transfer of community supervision from the Board of Parole to TDOC, the creation of seamless supervision model focused on reentry, and the appointment of the Governor's Task Force on Sentencing and Recidivism. The task force was appointed in August of 2014 and had 27 members from across the criminal justice community, including lawmakers, judges, sheriffs, district attorneys, and public defenders. The highly regarded Vera Institute of Justice served as a partner to the task force and provided information, data, and best practices. We met with a number of stakeholder groups to hear the challenges facing the state and ways those might be addressed. We also heard from various states and groups on their efforts on sentence reform and recidivism reduction. The final report from the task force included 16 recommendations focused on 3 key areas. Many of those recommendations were adopted and incorporated into the Public Safety Act of 2016. The first of those 3 key areas is addressing the violent crime rate. That meant focusing on the offenses that drive violent crime in Tennessee. Domestic assault offenses comprise about half of Tennessee's violent crime rate. So the act not only increased the penalty for third and subsequent domestic assault offenses to a Class E felony, it also provided a mechanism for ex parte and temporary orders of protection for victims. Additionally, the legislation enhanced sentences for third and subsequent convictions of aggravated burglary, especially aggravated burglary, and drug trafficking. The next piece of the legislation looks at smarter use of prison beds. This is something that hasn't been looked at or changed since the late 1980s and puts us more in line with a number of other states cross-country. The final piece of the legislation looks at reducing recidivism. To do this, we really focus on these key areas: a single risk and needs assessment tool, which informs the decision-making process, as well as programmatic placements in order to address the criminogenic needs and to ultimately reduce the risk of reoffending. Additionally, using administrative sanctions that are immediate and proportionate have a greater impact on offender compliance. Looking ahead, TDOC will really work on these 2 pieces of the legislation. As I previously mentioned, Section 13 requires the Department, the Board of Parole, and the courts to consider the risk needs assessment in making programming and treatment decisions, sentencing decisions, and post-prison supervision conditions. Section 14 talks about the authorization for the department to utilize graduated sanctions for violations of conditions supervision. 10 process action teams are working toward implementation, creating goals and task lists, as well as working on policy development and collaborating with each other to make sure that they're in alignment going forward. We have an aggressive timeline to transform legislation into policy, practices, and procedures. Policies need to be in place by October 2016 for intensive staff training. We will also be communicating and collaborating with stakeholder groups as we move forward. To sum it all up, a consistent use of a validated risk and needs assessment will result in offenders being better prepared for success. Also, utilizing an individualized case management plan that's driven by the risk and needs assessment will be a critical element in seamless supervision. Better outcomes will be produced when responses to non-compliance are swift and certain, and offenders who are more successful in community supervision means fewer admissions for non-criminal violations. All of these things lead to increased public safety.